Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, Child Support Summons. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All of my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, let's get to it. Okay, so now as you all know, every time you all receive any type of correspondence in the mail, no matter who it's from, it can be from the IRS, it can be from student loans, it can be child support, it can be from your credit card bill, mortgage, car note, whatever type of document that they sent you in the mail stating that you owe them some type of money. Always respond back to it, okay? Always. Even if they send you a summons to appear, always respond back. Never let nothing slide or go. And most definitely try to respond back within a 3-day period. Okay? So you have 3 days to really, once you receive it, to write your response and put it back in the mail, okay? The faster the better. Okay? In order to stay in honor. But let's read the definition of summons since we're doing the summons, since the title of this video is called Child Support Summons. Okay, so summon, in practice, to serve a summons, to cite a defendant to appear in court, to answer a suit which has been begun against him, to notify the defendant that an action has been instituted against him, and that he is required to answer to it at a time and place named. So again, the whole point of a summons is to inform you that a suit has been brought against you, basically giving you a duty to speak. To do what? To defend. Okay? To file an answer. Okay? So that's what you want to do. You want to file your answer, but before you want to file your answer before you go into these courts. Okay? Once you receive the summons, try to file your response within 3 days. Okay? Once you file your response, you file it to the court, send all copies of part of your send all parties involved a copy of your summons. Okay, not a copy of your summons, but a copy of the of your response to the summons, to your answer to the summons. Okay, so make sure you always file a response. The courts cannot deny you a response when you're filing your response in court to defend yourself. You have a right to defend yourself, so always file your responses into the court. But let's stroll up a little bit more. Let's go to summons. Summons. Practice, a writ directed to the sheriff or other proper officers requiring him to notify the person named that an action has been commenced against him in the court whence the writ issues, and that he is required to appear on a day named and answer the complaint in such actions. So again, they want him to answer the complaint, okay, in such actions. So as you all can see, now, with that being said, when you receive a summons, do not put it back in the mail. Do not send it back to them. Answer the complaint. If you do not answer the complaint, this is what's going to happen. It says, under code procedures, a summons is not processed, but is a notice to defendant that an action against him has been commenced, and that judgment will be taken against him if he fails to answer the complaint. Okay? So, if you do not answer the complaint, then it clearly states that they will enter a judgment against you. Okay? So, if anyone telling you all not to respond back to these summons and put them back in the mail and send them back off, next thing you know, you're going to receive a default order in from the judge claiming that you owe X amount of dollars, and they're going to start garnishing your wages immediately. Why? Because you had a duty to speak and you failed to speak. So by your failure to speak, you gave them the go-ahead, because your silence is acquiescence. You gave them the go-ahead to pursue and take whatever they want to take from you. Okay? So now, another tricky part about it is they tell you that you are required to come on a day and a place to appear, right? But by reading this, you'll think that, hey, you just go to court, appear and start arguing back and forth about a bunch of nothing. About, oh, I'm not the father, or I don't owe this much, I don't owe child support, this, that, and the other, starting a lot of controversy, bringing controversy to the public. No, you need to handle all your business prior to coming to the court. File all your documents, statements, and everything before entering into these courts. Because if not, you were going there empty-handed. Like the person that filed a complaint in the summons, they already entered their documents into the court. Why? Because the court only exists on paper, and courts can only hear paper. Okay? So you must do the same. You must respond back on paper so the court can hear you as well. Okay? And you can go in and challenge whatever you want to challenge, but you have to put all your facts on the record prior to going to court. So if you want to challenge jurisdiction, you would do that prior to going to court. Do not wait until you get into the court to challenge jurisdiction, because if you do, then by your appearance alone gave the court personam jurisdiction over you. And we're going to read that as well. So with that being said, let's go and check that part out just to make sure so you all can see everything I'm telling you all is true. Like I stated, I only deal with facts and truth. So let's go there. Okay, so as you all can see, we're going to pick this up where it says no jurisdiction, no authority, right? So again, no jurisdiction equals no authority. So just by you, when they send you a summons and you go to court and you appear voluntarily, you gave them jurisdiction. But let's prove that. Let's continue though. It says jurisdiction consists of in personam, subject matter, and geographic. Once challenged, jurisdiction cannot be assumed. It must be proved to exist. So again, once you challenge jurisdiction, they must prove it to exist. Okay? Do not wait until you get into these courts and say, well, you want to argue jurisdiction. By that time, it's too late. Why? Because you entered into their tribunal. You already entered into their court. Now that you entered into their court, you gave them jurisdiction by voluntarily appearing and showing up. Okay? Always challenge jurisdiction before entering into the court. Okay? Because they need jurisdiction in order to move forward. Jurisdiction is the first step in establishing the matter. But let's continue. Jurisdiction, once challenged, cannot be assumed. It must be decided. So once you challenge jurisdiction, once appearing to the court, they cannot assume that the court has jurisdiction. They must decide right on the spot if the court has true jurisdiction or not. Always challenge jurisdiction. But let's continue. No sanction can be imposed absent proof of jurisdiction, which is true. Okay? Another case law to back that up. Let's continue. The law requires proof of jurisdiction to appear on the record of the administrative agency. So who is the administrative agency we're dealing with? The child support agency. But let's continue. And all administrative proceedings. So if you have an administrative support order or administrative, you're going into these administrative proceedings, going before a magistrate, you must ask the magistrate to provide proof of jurisdiction prior to you even entertaining the question to come into these courts. Okay? Always challenge these situations before going into the court. Okay? Before you make a plea or anything, challenge jurisdiction. Let's continue. If the tribunal finds absence of proof of jurisdiction over persons and subject matter, the case must be dismissed. Another case law to back that up. So again, you can get the whole case dismissed by jurisdiction alone. It don't have to go no further. We can stop this thing at the gate. Okay, we can stop it from the beginning. There's no point of running. There's no point of sending these mails back and doing all that other nonsense. Face these people head on so you can get this remedy for you all can win in these courts. Let's continue. Jurisdiction is essential to give validity to the determination of administrative agencies, which is, again, the child support agency. And where jurisdiction requirements are not satisfied, the action of the agency is nullity. Okay? So, now you see how when I'll be putting up like motions to vacate and stuff like that, and we be winning, because we challenging the jurisdiction. We're standing firm. We know what we're doing. We're not playing games. We're not running from these people. We're facing them head on in the state. If they want to bring you into these state tribunals, be ready. If they want to bring you to these courts, be ready. Don't run. Don't hide. Stand up like a man and be ready. Stare them in their face and be ready. Have your ducks in a row prior to going into these courts. I tell y'all, do not wait for wartime to have your ammunition ready. Always have your ammo ready before you enter into these courts. You know, you can't be running back to the house to get your ammunition if somebody already drawn down on you. You should already have your ammo on you so you can draw back. That's how it goes. But let's continue. It says, also see the following for citations. Read, the person in certain jurisdiction must, when challenged, prove that jurisdiction exists. So again, if the agency bringing y'all into these courts saying they have jurisdiction, once you challenge that, the agency must prove that they have jurisdiction to hear the matter. Okay? But let's continue. Let's go. Let's do one more. I'm not trying to do all of them. Let's do one more. The top, it says, it is an elementary rule of pleading that a plea to the jurisdiction is a tacit admission that the court has a right to judge in the case. So what I was telling y'all, do not make no pleas in these court cases. None of that. You know, when you file your documents into the court and then stand on them. No pleas, no consent to jurisdiction, none of that. Be ready. But let's continue. And is a waiver to all exceptions to the jurisdiction. So again, we are not consenting to the jurisdiction. Let's continue. Every person born or naturalized in the United States and subject to his jurisdiction is a citizen. Okay? So again, hey, these case laws get no realer than this. But look, I'm not going to overdo it. So again, once you all get these summonses in the mail, always respond back. Okay? Do not run. Do not get scared. Do not panic. Respond back. Have your ducks ready, your ammunition ready. You know, challenge what their challenge their presumptions. Always challenge presumptions, man. Okay? And then state your facts and as you challenge these presumptions. But look, that's all I'm gonna do for today. If you all need my help, hit me up in my email at yahismagnified@gmail.com. I gotta get back to work. I got paperwork I gotta write up and everything else. So again, for all my brothers out there fighting, continue to fight. Keep y'all heads up. Ain't no quitting. Let's get this remedy. Everybody, let's get this remedy. It's time to stop playing these games and do what we need to do. Put our minds together. We gotta become more crafty, more clever. Because these people, they're changing. We got them in places that they don't expect to be in. And we asking them to prove things that they can't prove. So with that being said, again, I'd like to thank all my subscribers for watching. Like and subscribe. Also, hit that bell for the notifications so you all can get notifications when my videos are popping up. So with that being said, again, you all be blessed. Shalom.